Good evening, everyone. Thanks for joining us for episode 3 of Beyond the Headlines. I'm Richard Gearhart. For the next 30 minutes or so, we will be taking an in-depth look at what's happening in the Kristen Smart murder trial. First, though, let's get you up to speed on what happened this week in court. Testimony this week has focused mostly on the party that Kristen Smart and Paul Flores attended before Kristen disappeared. Monday started off with testimony from District Attorney Investigator James Camp. Then we heard from Kristen's roommate and several other students who knew Kristen or who had attended that same party. Paul's roommate testified that he asked Paul about Kristen's disappearance, and Paul joked that she was at his mom's house. Also today, hundreds of pages of previously sealed documents in this case were released, and the judge is considering unsealing even more. They include motions from the defense and prosecution, details about witness interviews, and other items of evidence. Court will not be in session tomorrow, but testimony is expected to resume again on Monday. And we'd like to invite you to share your comments and questions in the chat below. And if we don't address your questions tonight, we will be compiling them for future episodes. My guest tonight is retired San Luis Obispo Superior Court Judge John Trice. And welcome. Thanks so much for taking part of this with us as well.
My pleasure. Thanks for the invite.
You know, and literally those 300 pages, it was about 300 pages that just got released today. And I was going over those just prior to this over the last couple of hours. So nothing huge. I don't think it's anything that we haven't seen already, but why seal those documents in the first place, and then why unseal them as the trial's progressing?
Well, I haven't seen them either. It sounds like you've seen some of them. The reason they would normally seal something like that is if they have a feeling that if certain information in there were publicized, it might affect the ability to get an impartial jury. Now that the jury's been selected, there should be no need for that anymore. So I'm assuming that's why they decided to unseal it.
And then apparently the judge has said that she's considering other documents kind of a case-by-case basis, and the attorneys can make their case for keeping them sealed. Why would an attorney want to keep something still out of the public's view?
The only thing I could think of is if there is potentially inadmissible evidence in some of those reports or statements, and they'd not be allowed to bring that information out in open court. So they wouldn't want that released to the public and possibly, get in the hands of the jury as well.
So we've been getting lots of questions about the case as we've done the coverage, and then honestly, as I'm sitting up there in court a couple of days a week, I've noticed some stuff as well, and that's one of the reasons that we have this show, just to sort of talk to experts, people who have done it before. One of the things that people keep noticing is this idea that witnesses obviously are barred from the courtroom ahead of their testimony. So, it seems pretty obvious, but tell us why, from your perspective, why witnesses aren't allowed. And then once they're done testifying, they can actually sit in the courtroom for the rest of the proceedings, correct?
Right. So generally, they're trying to protect the integrity of the testimony. So what you don't want to have happen is all the witnesses are sitting in court listening to other witnesses. The fear is that maybe their testimony would later be tailored to fit other people's testimony. So generally, you'll have what's called an exclusion order. So if you're subpoenaed to testify, you can't be in the courtroom when anyone else is testifying. Once a witness is done testifying, they can be what's called subject to recall, which means they could be called back again. If they're subject to recall, they can't sit in the courtroom even after they've testified. If they're not subject to recall, then they can sit in the courtroom.
Yeah, I think almost all of the witnesses have been subject to recall so far. The one thing that I did notice, though, was that the Smarts the Smart family, so Denise, Stan, Matt, and Lindsay, the brother, sister, father, and mother, all testified early on in the proceedings and then weren't subject to recall. Is that done intentionally so they can listen to the rest of the testimony, or
yes.
Or does that even go into the decision?
No, it does. If you have particularly family members, and if let's say the defense wants to object to them being in the courtroom, the easiest way to get around that is to have them testify early, and then when they're done, they're not subject to recall, and then they can sit in there.
Yeah, and they have been sitting in for the majority of it. Interestingly, and obviously you probably can't comment on this as a judge, but in this particular courtroom, they have both juries operating at the same time. So one of the juries, plus some of the alternates of jury number 1 of Paul's jury, takes up almost half the audience space. And so they limit both the public and the media, how many members can be in there, and they have an overflow room. And interestingly, Denise Smart, the mom, has been choosing to sit in the overflow room as opposed to in the courtroom itself. Is that, I assume it's likely, we wouldn't know unless we can talk to her. I can't talk to her as a member of the media, but I'm assuming it's just so that she has a little more privacy.
I would assume it's a privacy issue. I've had cases in the past where family members of a victim don't want to be in the courtroom with the person that's accused of a crime like this. I don't know if that has anything to do with it. It might just be a privacy issue.
The other thing that I thought was interesting this week that kind of came up was that the jury, obviously the two juries don't fit into the jury box, right? Not even the one main jury, plus there's 8 alternates. At this point in time, 3 have been excused, so we're down to, I think, 38 total jurors in the courtroom. But so some of them have to sit in that audience section, but they are starting to move them around. Is it important to have a perspective from sitting in the actual jury box? Like the bailiff has actually literally randomly moved some of them so that some of the alternates get to sit in the chairs and move around. Yeah,
I think it's just a comfort issue.
Okay, yeah, I just wondered if there was something to that, or because they made this big deal about we're kind of moving people around, but yeah. Any problems, and were you ever involved in a case where they had 2 juries operating at the same time?
No, I wasn't. It's a logistical nightmare. And of course, the reason they're doing that is there's some evidence that's admissible against one defendant and not against the other. So you can either do 2 trials, which I had done in the past, but if they're talking about this case going into September or October, I don't think you'd want to try that twice. So you go to Plan B, but it's just a logistical nightmare, moving people in and out, trying to figure out which jury should be in there for which witness. If a witness starts talking about something that doesn't affect one defendant, there's going to be a break. It's good luck.
Yeah. It has been kind of a little bit of a nightmare, and even on Monday, court was about maybe 25 minutes late getting started while they waited for juries to, because you got 39, at the time it was 38 people, 1 never showed up, so ultimately they swore in an alternate juror. Yeah. What are the dangers with the trial going on so long and having only that's a lot of alternate jurors, but only 8 jurors? What is the danger of actually moving through all of them before the trial's over?
That's a lot of. We did the Krebs case up in Monterey. We had 8 alternates. I think we only used like 2 or 3. Most cases, even if it lasts 2 or 3 weeks, you normally only have 2 or 3 alternates. So 8 is, I would think, more than enough.
So we're kind of jumping all over the place, but you brought up Krebs, and I wanted to talk to you about that too, because you were the prosecutor in that case, yes. And that was one of the few cases that actually got moved also because of pre-trial publicity. So is that kind of odd that our county's had 2 cases? And tell me kind of a little bit about how that works once you get moved to another county.
So any case that has a lot of pretrial publicity, you can normally anticipate, as a prosecutor, for instance, that there's going to be a motion for change of venue. Change of venue is unbelievably rare, as you well know. Even the O.J. Simpson case didn't have a change of venue. You see it in smaller counties like ours. Ours is a sort of a medium population county. But if you have a smaller county like ours and there's a lot of publicity like the Krebs case or like this case, you can anticipate that motion. And I wasn't surprised at all to see it moved.
When you were moved with the Krebs case, was it your decision to travel with the case? Can it be reassigned to a prosecutor in the county that accepts it?
No, the prosecutor and the defense, the prosecutor particularly always goes with the case. The defense may try to get out of the case, saying it's a hardship on their business, for instance. The judge normally goes. I was sort of surprised the judge in this county didn't go. When we went up to Monterey for the Krebs case, Judge LaBarber was the judge in San Luis Obispo, and he traveled up there with the case as well.
How important is it to kind of travel? I would think that if the judge has already done the preliminary hearing, then they're kind of familiar with some of the evidence.
Exactly.
And there's some carryover. And actually, this judge is actually a fairly new judge, isn't she?
I don't know her. I read a little bit about her. I got the impression she was young and a newer judge, but it looks like she's got some great reviews. A lot of people like her, so it seems like so far she's doing a great job.
From a judge's standpoint, is it intimidating to take on a case with this much publicity and this much going on?
That's the reason I was sort of surprised that the judge from San Luis Obispo didn't go with the case, because there were so many pretrial motions. There's so much discovery, if you will, evidence, reports. You've seen a lot of them. Yeah. And then to all of a sudden be a judge in a different county and trying to pick that up, that's very difficult to do. We'll see.
So one of the other things that keeps coming up with our viewers watching, and I kind of want to know this too, and this might be kind of a funny question, but you see a lot of these conferences between the defense and the prosecution, right? So there might be an objection, or they might interrupt, they'll ask for this conference. They always leave the courtroom and go back into the hallway. What's going on during those discussions, and are they really adversarial, or is it like sort of, friends getting together and sort of deciding an issue and then coming back in?
Well, the reason someone would ask for what's called a sidebar is that they don't want to discuss in front of the jury the issue that they want to raise. So, in other words, you could make an objection that's irrelevant, and then the judge may say, "What do you mean by that?" And they say, "Well, can we have a sidebar?" Because they don't want what's called a speak an objection in front of the jury, which might taint the jury, cause a mistrial, and have to start all over again. So they have sidebar conferences. This isn't a death penalty case up there, but if in a death penalty case, all those sidebar conferences have to be reported. In a case like this, they can have a sidebar conference, and then in conjunction with perhaps the next recess, put whatever they wanted to put on the record about the sidebar.
So like in a death penalty case, excuse me, the court reporter would follow them out, and then in this case, they just make an addendum to the record, if you will?
Yes, correct.
So can it get contentious between the defense and the prosecution, or are they pretty professional?
They're pretty professional. I know Bob Sanger, for instance, probably one of the best defense attorneys in California, quite frankly, and very professional. I've seen him in court many times. The prosecutor has a great reputation. I don't see those two gentlemen getting in a situation where one's angry with the other. They're just respect each other and respect different points of view.
How much do the attorneys actually consider what the jury's taking in? I can't help but sit there and think that yes, it's about the evidence. Yes, they get a lot of jury instruction, but it has to be a little bit about a connection between the attorney and the jury. It's got to be something to do with believability. It has to have something to do with what the defendant looks like. I can't see a jury 100% being able to eliminate those types of emotions and evaluations.
No, you're 100% correct. I mean, when you get right down to it, by the time you get to a trial, it's a presentation. And so the lawyers are sort of the salespeople, and if they don't like the salesperson, they're probably not going to like the product. So it's got to be presented in a way that in my opinion, it flows smoothly, is not confusing, and hopefully, if it's done that way, then you can convince a jury of your position.
Speaking of that, who decides the order of the witnesses, and does it matter? Are we aiming at something? Do we try to start strong? Do we try to end strong? Or, like, where do we put the expert witnesses in there? Does it matter? I noticed that some of the witness, so far for the prosecution, the witness order has been a bit different than the preliminary hearing.
The prosecutor, well, as you're well aware, the prosecutor goes first. The defense doesn't have to put on any evidence if they don't want to. But whoever's putting on the evidence, whether it's Mr. Sanger or the deputy district attorney, that's the person that makes the decision what the order of witnesses is going to be. And then it's just a matter of art, if you will. Do you want to, what I would normally expect to see is if you're going to have a lot of testimony about a location or a room or a vehicle or something like that, I think you would want to establish early on, maybe with photographs or videos, so the jury has a picture in their mind when someone says, yeah, I went in the room and I went over to the right side, or I was walking down this street. So I think you want to sort of set the stage that way. And then I think generally it's a good idea to go in chronological order. And as you just mentioned, I think it's also a good idea to have a strong witness right off the bat, not some expert witness, put that more in the middle, and then finish out at the end with something strong as well.
For the jury, and obviously you've done this for a long time as a prosecutor, connecting with the jury, and then as a judge, obviously lots of, they get lots of jury instructions as the trial's moving on. But how hard is it for the juries to sort of get used to what's happening in the court? There's even some terminology, for instance, they're constantly asking you for permission to publish evidence, for instance. What does that mean, and how does the jury sort of get in tune with what's going on in the courtroom?
Okay, so let's say a photograph. So you have a witness, and the side shows them the photograph, and they look at it, and they say, "Do you know what that is?" That, yeah, I took that picture. This is on whatever day it was, and this is a picture of such and such. So that testimony right there is called foundation testimony. So now you have a witness who has identified a photograph, and now it's relevant to the case. And so then the moving party would say, I'd like to offer that photograph into evidence. Any objection? No objection. It's received. So now it's in the record, but the jury hasn't seen it. So it's always a good thing to do, in my opinion, once it's been received into evidence, to ask what's called to publish it to the jury. So you actually take the photograph, go over to the jury box, they pass it all around to everyone, and it comes back to you.
Yeah, and that obviously in this case that takes a while, right?
Yeah.
Because some of these things
Right.
are like big posters, and they're literally, ask for permission to hand them to the jury because the jury is so huge.
Right.
There's two
Right.
juries in that.
Yeah, and so, and if you have, like, I'm sure they probably have hundreds of photographs by the time this case is over.
Yeah.
You don't want to do that one at a time. What I used to do is maybe do 10 or 20 at a time and then publish those. So yeah, because you're right. You start passing a photograph around to 40 people.
Yeah, and I've noticed that the attorneys are almost kind of help each other out a bit. Like at one point in time, Sanger said, "Yeah, I have no objections to pictures,
Right.
70 through 85 or whatever." You know what I
Good.
mean? Because there was
That's
a
good.
stack of
Yeah.
them. So
That goes back to your point that they're getting along and they're not butting heads and not trying to cause problems. Because if you start arguing over things that aren't that important, the jury doesn't like it. They realize it's a waste of time, and that affects your credibility in front of the jury, in my opinion.
yeah. So back to the witnesses being in the courtroom. So another question that has come up, and I asked you about this earlier, but now you're going to have to say it for the rest of the people watching as well. But the investigators are exempt from that, right? Because they are sitting in the courtroom, and for instance, James Camp, a DA investigator, testified at the beginning of this week, but he's been sitting in the courtroom the entire time, and he's exempt from that being excluded from the courtroom.
Yeah, whether it's a civil case or whether it's a criminal case like the one we're talking about, under the evidence code, the judge can exclude witnesses, which we talked about a little bit ago. But there's a specific exception or exemption, if you will, for an investigator for either side to be there. So if you have a case that involves multiple agencies, maybe Cal Poly Police, the DA's office, the Sheriff's Department, and each of those lead investigators from those agencies had a lot to do with the case, all of those people can be in there with the court's permission.
One of the things that keeps cropping up is, it's been 26 years, right? So it was in 1996, and so the witnesses are having difficulties recalling, what was happening. We see a lot of times, either attorney will say, "Hey, can I offer you? Would looking at your original statement to detectives help you better recall what happened?" Does that create a problem with credibility with the jury, or are they okay with people sort of refreshing their memory? And one of the reasons this came up is because we had this conversation in the newsroom just a few minutes ago, right? And at first I was saying, gosh, they can't remember anything. But then when I really started thinking about it, I've been working here for the entire time this case is going. Sometimes I have trouble remembering my co-workers' names from 1996. It's not out of the question to forget something over a 26-year period of time.
Yeah. Yeah, so in my opinion, the best way to prepare a witness, let's say it's a week or two before trial, you gather up all the statements they've made, whether it's, let's say, to the Cal Poly Police Department, the Sheriff's Department, the District Attorney's Office, the FBI, whomever. You're preparing the witness to testify, and I would give them all those statements and say, these are all the statements I know about. Number one, are there more that I don't know about? And if not, can you look over all of these while we're sitting here and tell me, are there any mistakes in here, anything you want to change? And I would even give them those statements so they can review them to refresh their memory, so you don't get in a situation too often like that. Of course, they're subject to cross-examination. You reviewed your statements before you came to court, for whatever that's worth. And so that's one way to try to avoid, I don't remember, because it's sort of takes away from the case if every other question is, I don't remember, and you have to refresh their recollection. In my opinion, if someone had done that ahead of time, it would have gone a lot more smoothly.
There is a little bit of what I would personally call kind of gamesmanship with this, though. Whether we're calling it like coaching the witness or preparing the witness. I think the attorneys are kind of choosing their words carefully to sort of sway the jury a bit.
A bit, probably. Yeah, that would be the downside. The cross-examination would be, well, before you came to court, didn't the prosecutor show you your statements? And, well, sure. That's, if I was going to testify about something that happened 26 years ago, I'd like to look back at some statement that was contemporaneous with the events, as opposed to trying to remember something 26 years cold.
And honestly, you have to give the jury credit for, most people are going to be able to do that.
Right.
Is that true? I mean, have you seen juries have trouble with that, or?
With
With accepting the fact that people are, people are going to be human, right?
Right. Exactly.
And how much how much instruction is the jury given in terms of like how to assess credibility of a witness?
Yeah, there's a specific instruction that's given in every criminal case about credibility of witnesses, and it talks about how well they can remember. Did they make a statement in the past that is consistent or inconsistent with their testimony? Importantly, in my mind, they're told what was the demeanor of the witness while testifying. So if you get a combative witness on the stand, that's probably going to adversely affect their credibility in most cases. And there's probably about 15 other things in that instruction, but they're given a pretty specific instruction about how to judge witness credibility. And eventually it's up to them.
Right, the jury.
Right.
Yeah. But I have noticed that many of the witnesses are quite nervous, but that's to be expected, right?
Yeah. Absolutely.
Yeah, one of the things I want to talk about, and we're kind of running out of time, I could talk to you about this for a long time. We'll invite you back so we can keep asking these questions again. But there's a lot of talk about Chris Lambert and whether or not he is allowed to be in the courtroom. He is allowed to be in the courtroom right now, and whether or not he would be called to testify. And one of the reasons is because there is some question, as you would expect now with newer types of social media and types of media in general, whether he's a journalist or not. How complicated is that as, sort of technology changes, but the court laws don't necessarily keep up?
So, I'm sorry.
So I guess the question is, how do you decide whether somebody's a journalist? How do you decide whether somebody's going to need to testify or not, or is protected under these sort of laws that don't keep up with what's considered media now?
Yeah, well, so a journalist would probably, he or she would be reviewed, in my opinion, just like any other expert witness. Are they performing a service or a task that isn't like your average layperson? And it doesn't take much to qualify as an expert witness. And so if you have someone like that who's either published something in writing or published something on social media, I think it would be pretty easy to designate them as a journalist for the purpose of the discussion.
When you're a judge, though, how much training are you given? All of a sudden you're having to. I always joke that as a journalist, right, I have to be sort of a jack of all trades, and I'm not necessarily. I have to be a quick study on whatever I'm doing, right? But on the same token, you're put into that spot sometimes, right, to say, is this a journalist? Is this not a journalist?
Right, and it's a very unusual question, and so that's not something. If you're a judge, that you're going to know off the top of your head. When the issue comes up, it would normally be briefed in writing by both sides, to either have the person recognized as a journalist and the privileges that apply or not, and then you'd review those. The person would probably testify outside the presence of the jury, and then you'd have to make a decision based on past case law on how to proceed.
So, and one of the things that kind of crept into this case is that, and I literally just reviewed some of those documents like an hour ago, but when I was reading it, the judge sort of made the statement, look, he's producing content which is for public consumption about the case, right? And it's neutral in its approach, presumably. But he says right on the podcast, I'm not a journalist. How much would that hurt? Obviously, it didn't hurt in this case, right? They considered him a journalist, but
in this case, I'm not sure why he would have even said that, but eventually it's up to the judge to make that call, no matter what the person says. Let's say he said the other way around, I'm a journalist, and you start looking at what he or she's been doing and figure, no, you're not. Yeah. So it's up to the judge.
Yeah. In cases like this, where there is a lot of pre-trial publicity, how do you think that the public can really understand what's going on, or does the media do kind of a disservice in that we're showing kind of little snippets of this case and not the case in its entirety?
I'm sorry, so you're talking about?
I mean, in this case in general, I'm getting a totally different feel from sitting in court many hours a day, right? But at the end of the day, I'm sort of producing a minute and a half or 2 minutes of content. Okay. How much do you think the public actually understands what's going on in these trials?
Well, it's interesting because I used to tell the jury that I talk about, you're not supposed to read anything in the paper, or you're not supposed to read anything online, you're not supposed to listen to the radio about the case, et cetera, et cetera. And I used to tell them the reason for that is, we'll be in here 4, 6, 8 hours every day. The media comes in, they sit here, and in 2 or 3 minutes, they're doing a synopsis. And many times, what that reporter may be reporting isn't real accurate, if you will, about what happened over the whole day or what's happened over the whole trial. So that's one reason we try to keep jurors away from media input during the trial.
Once the trial gets started, is there a danger of the public sort of seeing too much? Like, do you worry about what's going to happen on appeal? Do you worry about a mistrial and having to start it again? Or is it, once the jury's seated, you've got your unbiased jury and you don't have to worry about it so much?
No, one of the biggest reasons cases get reversed is jury issues. I mean, you'll get people from time to time that clearly don't want to be on the jury, and they're saying things during jury selection that's pretty outrageous just to get out. And some judges always tended to try to force them. And when I was doing that job, I would say, no, if they don't want to be here, I don't want them here. But I want people in here that are willing to make the public commitment and are willing to listen and make a decision, not someone that's going to be constantly trying to figure out a way to get out of there.
But in long trials like this, it is a little bit, at least from a layman's perspective, concerning, because there are only certain types of people who can dedicate 3 months of their lives, right? So is it really a jury of your peers at that point?
Yeah, that's what happens. I mean, you can be excused from jury duty, as you're probably well aware, if you have what's called an extreme hardship. Whether that's a health issue, you're taking care of someone else, whether you're personally, you have your own business, you can't take 3 months off your business or you'll go under financially. A lot of issues like that.
What about the issues of timing? I was trying to sort of look at all of the jury members last time I was in court and kind of do a cross section, like how old are they, gender, ethnicity. There's a lot of young jurors on there deciding a case where they don't really understand how life worked, right? Like, there weren't cell phones, and we weren't checking in with our moms several times a day, and there weren't GPS trackers. Is that going to matter in this case?
It's interesting that they would pick a younger jury. The reason I would think you might want to do that is if the events basically involve the comings and goings of young people in college. Maybe the thought by the lawyers is that younger people in college or just out of college may understand the social dynamic a little better. That's the only reason I could think.
And we're kind of running out of time here, and I don't mean to put you on the spot if you can't answer this, but how difficult is it to get a jury to sort of to put the pieces of a puzzle together where there is no body and there is no, is it hard to get a conviction with such circumstantial evidence?
It's difficult if you don't have a body. As you're probably also well aware, there have been cases in our own county here where cases have been prosecuted without a body, but it's very difficult. I'm sort of assuming that the prosecution is relying on statements maybe made by Mr. Flores. I'm not all that acquainted with the evidence that was recovered from the house or the expert testimony regarding what was found there. But without a body, it does make it more difficult, of course.
Well, I want to just say thanks again for you taking the time to do this. It's fantastic, because I think it really gives our viewers kind of a different perspective of what's going on, and we can't really do that without people who have walked the walk and talked the talk, so we appreciate it.
My pleasure.
And we want to thank all of you for joining us for this special broadcast as well. And again, obviously, thanks to my guests, retired Superior Court Judge John Trice. We will not have an episode next week, but we will be back the week after that. And remember, you can always ask any questions that you may have about the trial in the comments below or during while you're watching this special Facebook edition of this coverage, or you can just email the questions to us as well. We will be compiling them for future episodes, and you can always find all of our coverage of this case on our website, ksby.com. So thanks again for watching, and we'll see you next time.